United Auto Insurance Company versus Barahona.
May it please the Court, Thomas Lunker on behalf of United Automobile. I'd like to reserve 2 minutes for rebuttal, please.
All right, thank you.
In this case, this is arguably the most important issue in PIP litigation right now, is the applicability of the 2008 fee schedule. And I know this Court had heard a very similar case back in April, so well acquainted with the
did you argue that case? It's the same panel, I believe.
Correct. I was not. It was the U.S. Security.
Ms. Reese did.
Correct.
Sure.
Are there other cases that you're aware of that United Auto has within our district on this issue?
At the circuit court level, we have
here.
In this court, I believe we have one other case. I'm not 100% sure, but I know that we have at least 2 in the 4th district right now.
And the 4th district has decided the case, has it?
It has in Kingsway. However, there's also a Geico case that's pending in the 4th district, which they asked to waive oral arguments, but the court said, no, we're going to set this one for oral argument.
Counsel, you realize that there is an obligation in this court that you file a notice of related actions?
I did not realize that.
On the notice of oral argument, I believe is where it appears. Would you please file a notice of related actions and file something in this case to demonstrate what other files there are out there that United has?
Absolutely.
On this issue?
Absolutely, I will do that.
And if Ms. Reese knows of others of the same type in the court, she can do the same.
Certainly.
I have 2 questions. If in the course of your both of your presentations and answers to 2, I promise, I will not ask another question. Number 1, how does this, if at all, case differ from the one that was argued earlier? And number 2, why isn't the 4th district correct and shouldn't it be followed?
Okay, as to the first question, the difference between the U.S. security case and this case is that the U.S. security case involved what's called the gap policy. It's a policy that was incepted during the window that PIP was repealed. Our case involves a policy that was prior to the gap period. So we refer to this as a bridge policy because all the other relevant events occurred after.
You're saying in U.S. security, the policy was issued between October 1st and October 11th, or whatever that 10-day or 11-day period was?
No, I believe it was between October 1st and December 31st.
That's the gap.
It
was issued during that period, whereas this one was issued prior to that period.
Prior to the gap.
So what's the significance of that?
I don't think there's any significance.
How about
well, maybe one was put in green ink and one in black ink. Let's talk about things that matter.
Okay. I don't think there's any relevant significance from our perspective.
In the U.S. security case,
the question that I'm about to,
in the U.S. security
that I swore not to ask.
Didn't the policy language in the previous case that you're not a part of include the PIP statute as amended, language which is missing from this policy?
I believe it did, and the Kingsway policy included that language as well.
And the as amended language.
Correct.
So you have more of an uphill battle in this case because your contract does not incorporate or seek to incorporate future legislative action.
That would have been a helpful fact. However, I think that the statute...
You don't get helped by anything but what's in your contract.
Exactly. Well, our contract does say we will pay in accordance with the no-fault law. It doesn't say which particular no-fault law I will follow. And
that's not your best argument, though, right?
I think my best argument is certainly the legislative intent, which is stated quite clearly.
Well, we don't much care about what the legislature was thinking. We might care occasionally on what they did.
Exactly, and that's what 67.7.
All they did here was put in a permissive feature, and the issue has nothing to do with retroactivity or prospectivity or anything of that nature, but rather whether or not that feature was incorporated into this particular contract, not somebody else's contract, but this particular contract.
Right.
And we know the sovereign cannot change contracts, right?
Yes, that's correct.
And so you lose.
I disagree respectfully, Your Honor, and this is why.
How do you win?
I think we win because subsection 5A1 and 5A2 are both permissive methodologies. 5A1
just says you pay 80%.
if I could refer Your Honor to some language in the statute, actually, it does say may.
I'm talking about the contract.
The contract did not include a methodology.
Right. It says, the contract just says 80%, and then gives an alternative.
Correct. So under the contract, you always had to look to the statute to find out how to compute reasonableness. Because reasonableness is...
Look at the statute if the contract says reasonableness.
Reasonableness is the overarching standard.
The legislature doesn't get to determine what's reasonable or what's not. The law does.
Well, I think that's...
Unless it's incorporated into your contract somehow.
Your best argument is that all the legislature did was refine the methodology for determining what's reasonable.
Correct. Under both the 2007 and the 2008 statute, we could rely on fee schedules in determining what is reasonable.
But what they've really done is they've eliminated an issue of fact that a trier of fact may have to determine by establishing a schedule or a percentage from an existing schedule. So there's really no computation anymore. You look at the schedule, you multiply that times 0.8, and that's it.
Exactly.
Versus some trier of fact having determined what's reasonable and necessary, right?
Exactly. And
you're saying those are two sides of the same coin? That that's simply a refinement or a substitute methodology?
Well, the difference is that the cause of action, when you're referring to whether a jury has the right to decide what is reasonable, the cause of action in this action didn't accrue until after the statute was already incorporated into the policy.
Well, but the right
that's the issue.
The contractual rights vested at the time the contract was signed.
When we're referring to contractual rights, we have to be careful because the plaintiff is alleging two types of contractual rights, one being the provider's alleged rights and one being the insured's alleged rights.
And the provider stands in the shoes of the insured.
So you have to look at what the insured...
Might have been, the insured might have been on your side of the table, is what you want to say.
Exactly.
But the insured gave its rights to the provider, and there's no law that says that somebody who receives those rights must exercise those rights in their own favor, is there?
Well, we do have to look at, when we interpret insurance policies, we have to interpret it in the light most favorable to the insured.
We're looking, I suppose, but if the insured wishes, if the insured had not assigned this contract, and if it came to you and said, to United and said, we don't want to use the permissive provision, we want to pay our provider 80% because they're really good and they otherwise might go out of treatment of PIP people. That would be a perfectly legitimate contractual position for that insured to take, and you could say nothing about it, right?
Well, actually, Your Honor, an interesting thing is that this, almost the exact same argument was made in the PPO cases when they were interpreting the PPO provision of the PIP statute, and the medical providers had assignments of benefits from these insured, and they were alleging that, we don't have to accept the reduced PPO rate because this insured didn't have a PPO policy. And they said what the court said, both the Supreme Court and I believe also the Second District and several of the other districts said that what they're trying to do is turn a permissive word, into an implied prohibition. In other words, you may not unless you put this in your policy. And the court said, since it's permissible, then why can't the insurance company exercise that?
Do I understand correctly that this issue only arises with respect to policies that were purchased, that went into effect prior to January 1st of 2008?
Not according to the plaintiff's argument. They're saying that this applies to all policies, even post-January 1st, 2008, that do not have some sort of indication in them.
I'm getting at the discretionary. We have the discretion as to whether to take this or not.
Sure.
Is there a question out there about renewals? In other words, if the policy became effective prior to January 1st of 2008, is there a question out there about renewals?
About renewals?
Renewals of the policy.
I believe that unless the language of...
I hope I'm not giving anybody any ideas.
Well, the truth is that the Department of Insurance has to approve all all policy amendments, and so it took insurers some time. I think
to get this, and I suppose I'm heading afield here to some extent, but in this case, for United henceforth can put this permissive provision in its policy, and that solves the problem, right?
It might, but here's the wrinkle in that, is that the statutory structure gives the insurance company the flexibility to choose between whether they want to measure reasonableness by usual and customary, Medicare, workers.
It can put both in their policy and be completely safe, have the safe harbor, and have the contract go and choose.
Right, but
right?
The question...
Nothing wrong with that, really.
Sure, but why should the insurance company be punished for not doing something that it legally wasn't required to do in the first place? I mean, unlike healthcare under Part 6 of the Insurance Code, the healthcare statutes actually include a provision that require insurance companies to select one particular methodology and put that in their policy. The No-Fault Act does not contain a similar provision.
Do you have a case that supports the proposition that you made in your brief that as to the assignee, this is not a retroactive application because the assignment occurred after the effective date of the new statute? Do you have a case that supports the proposition that an assignee takes the assignment subject to a change in the law that occurs after the time that the contract was entered into, but before the assignment?
Well, if we're looking at whether the provider can assert rights differently than the insured,
I would
cite the court to the case of Orion versus Magnetic Imaging Systems. This is a third district case, 1997. In that case, the provider didn't want to comply with the arbitration.
That's the EUO case you're talking about?
It was an arbitration issue.
I apologize.
They didn't want to apply the arbitration provision, and this court held that, well, if you don't want to participate in arbitration, then don't take the assignment of benefits.
I'm talking about contractual obligations that are changed as a result of statute. You're suggesting that this isn't really a retroactive application because the assignment occurred after the effective date of the statute, right?
Right.
So even if it was retroactive as to the insured, you're suggesting that it's not retroactive as to the provider.
There is a case, let me find it, I have it in my brief. It says that Lauren Kyle Holdings versus Health Peterson Construction Corp., they say that an assignment vests the assignee with the right to enforce the contract. So if you're looking from the provider's perspective, their rights didn't vest until after the incorporation of the statute.
So you're suggesting that the assignee takes less rights than the insured gave?
No, I'm just saying that from their perspective, the provider is not harmed. At least they had noticed that this statute would be incorporated into the policy.
So the choice was to not take the assignment. That's what you're saying.
And that's consistent with this court's Orion holding from 1997. And that is one of our arguments. But even if it weren't, if it were retroactive, we are dealing with a situation where it's not a substantial impairment of the insured's rights. In fact, as I argue in my brief, this is something that benefits the insured. They're paying lower co-payment. They're getting to use more of the...
I'm willing to cede the rest of my time to Judge Schwartz down here, but really...
I refuse to accept that offer.
Senator Schwartz declined, but all right.
Besides that, you don't have any time. There's no consideration for that offer.
I think you're right. I'm not going to ask the question.
All right. If you want to save a couple of minutes for rebuttal. Reese?
Good morning. May it please the Court. Marlene Reese on behalf of the plaintiffs below. The provider was Ann Medical.
The only question here, Ms. Reese, is whether or not this statutory provision can be incorporated into the contract. The contract doesn't permit it in this particular case, and so this is an affirmance. It's that straightforward, correct?
It is very straightforward, and I can expound on that.
We can talk about all sorts of theories and what the legislature was thinking, or
the case is about.
I'll leave it at that, but that's what the legal issue is.
Can I get your time now?
Yes, I will cede the time. I'll cede the rest of my time. I won't ask any further questions. Well, I meant it.
It seems to me that this is not a straightforward issue because the insured who is the party to the contract has an interest contrary to that of the assignee. The insured wants to have the limitation on the bill, to make a long story short, or payment on the bill. The assignee doesn't want to have any such limitation. How can the assignee take more rights or rights that are contrary to the interest of the assignor?
Well, first I would answer that we don't know what the assignor
all of this is implied. It's got to be implied.
It is and it isn't, Judge, and I'll explain why. Because United and the insurance companies are focusing on just the fee schedule. We have a situation where a contract was entered into when the 2007 policy was in effect. As the court recognizes, this is not a gap policy. They're arguing that 627-7407 takes the entire brand new statute and dumps it into the existing statute. There are
existing contracts.
Well, they're saying yes, but they're saying that basically it replaces the 2007 statute that was in effect, and there are many differences between the 07 statute and the 08 statute.
You know, if you were representing the insured, I would be much more sympathetic to your argument, but you're not. I mean, we're not. I mean, who's kidding who?
And I don't.
You are representing a huge industry created by the TIP contracts, and they are representing the other side of the industry. They're the ones who are paying you. They are the ones who are responsible for your economic existence.
I agree with the court that, in effect, the medical provider stands in the shoes of the insured. And there is no, within the context of PIP, there is no case to the contrary. This case is about Menendez. Menendez, first of all, to get back to Your Honor's last question at the last oral argument, the Pomponio issue, Pomponio is not mentioned in Menendez. And it's a contract case, and Pomponio applies arguably in contract cases. Menendez doesn't talk about Pomponio. Menendez is very straightforward, where they say that a newly enacted amendment to an existing statute cannot be retroactively applied to a pre-existing contract because it is substantive and it affects the insured's substantive rights. There's no discussion of Pomponio and there's no balance.
Is it a substantive right as to the computation of a particular interest, of a particular claim?
But it's not.
Is that a substantive right? Isn't that the same as arbitration as opposed to a jury trial?
It is not simply a methodology. Because
it is a methodology. The legislature is saying you're always entitled to reasonable MRI, reasonable cost of MRI. The new statute says you compute, we have determined that reasonableness is computed by the 80% theory.
What the statute says is it says the insurance company is liable to pay 80% of reasonable expenses.
Yes.
Then they add a permissive portion that says the insurer may apply these fee schedules, which implicates some other provisions that are not necessarily in the insured's benefit. If they wanted to simply regulate fee schedules...
But we're not talking about the other issues. We're only talking about this issue. We're only talking about this is a MRI, right?
It's a single diagnostic treatment, and I believe that it was an MRI. The problem is that you cannot take the entire statute, which includes the permissive fee schedule.
But we don't have to rule on the entire statute. All we have to rule as to this particular entitlement.
You're saying it's a necessary corollary. If we agree with United, then we're saying that the entire statute applies.
But we're not saying that.
The only way that you can get the fee schedule.
We're saying, again, this is a matter of law, not logic. We don't have to. The only issue is whether the insured is the contracting party is adversely affected by the particular item that we are talking about. It's only then, if he or she is adversely affected, that the constitutional provision against the retroactivity, the inviolability of contracts applies. I mean, the insured is not going to object to something that gives him more rights.
And I'm not sure if I'm making myself clear. It's our position that you cannot simply say, and United Counsel below conceded that there were many other parts of the statute.
But we're not talking about those. We only have to deal with discrete issues here. But we're not worried about the other things when we're worried about that when that happens.
But Menendez says that the PIP statute as a whole is substantive. So you cannot take pieces of it out and apply them to a pre-existing
the new PIP statute gives the insured more rights.
Okay, what is? The insured is not entitled to them because the insured entered into an 07 contract. The insured entered into a contract in 07 where there was an existing statute, and that statute and that contract set forth the parties' respective rights and obligations. The legislature is not allowed a year later, regardless of the fact that the accident occurred and the treatment occurred.
When did the treatment occur?
The treatment occurred after, and the accident occurred after January 1st, 08. So they're saying it's not a retroactive application.
Yes.
Menendez says you don't look at when the accident occurred, when the treatment occurred. It's right in, I can read it right from
date of the contract.
It says you look at the date of the contract. The Supreme Court has...
Did I ask you about the last time about the case that I wrote involving there's a provision in a medical expenses contract that says you don't get daily services for taking care of the elderly usually, unless you also have a professional involved. After the contract was entered into, the legislature declared that provision invalid. It says that the insurance company cannot provide for such a thing. After that provision is made, the lady incurs expenses for a health care provider without having a professional. The insurance company denies liability on the basis of this is retroactive. And we said, among many other things, in disagreeing with the insurance company, that this is not retroactive application because the services were provided or not provided after the statute forbidding such a provision. Frankly, I was very dubious about whether that was correct. But it went to the Supreme Court, and for what it's worth, it was review was denied. Isn't that case contrary to your position?
I think that in light of Menendez...
Or left that paragraph. And this was after... Well, I don't know whether it was or not, frankly.
I don't remember the name of the case. I have to imagine that it was not after Menendez, but if it was, obviously the argument would be different. If it wasn't after Menendez, then I think as courts subsequent to Menendez have held, that Menendez governs, particularly in the context of PIP. These are not insurance contracts that are negotiable. You don't even have the option to buy PIP or not buy PIP. You're forced to buy it. You can't negotiate the contract. Then the legislature enacts all sorts of provisions and hoops that the insurers have to jump through, and the Supreme Court has said you cannot do that. The Supreme Court has said, A, that PIP is different, and B, that you can't affect the substantive rights of the insured if there is a PIP statute in effect at the
But
time.
this claim, this case, which is the provider versus the insurance company, implicate that issue?
I believe that it absolutely does. I believe it absolutely does because the change in the law adversely affects the contractual rights of the plaintiff insured. In this case, the change in law has nothing to do with the rights of the insured.
Would you agree that if we were to apply Pomponio, our consideration can only be the interest of the insured and not the assignee?
I believe that there's no distinction here between the medical provider and the insured, and I think
isn't it true that the insured in the policy would, if the person had the ability, choose the less expensive payout, and if it is the permissive fee schedule, that's what they would choose?
If you were just looking at 5A2F and only that portion that said that the insurance company may permit.
Yeah,
that's all you look at when you determine amount of payment. 5A1 or 5A2. It's 80% or it's the schedule.
Well, but you're asking me if the insured would prefer the insurance company to adopt the fee schedule, and I have to say, not necessarily, because you can't ignore the other provisions of 5 that are implicated because it's a package.
It's not a package. It's not a package. We don't decide cases on the basis of broad principles if they can be determined, as they should be determined, on the basis of a very discrete issue which is before us.
Would you concede that if we conclude that this is a change in methodology and not a substitution of schedules, that you would not prevail? If we simply conclude that this is merely a change in the methodology for defining reasonable medical expenses or necessary medical expenses?
I think that we still prevail because I think that under Kingsway, which has found that it is an alternative methodology that is not consistent with the mandatory methodology, it needs to be included in the policy. Now, in this case, because there was an 07 policy, obviously there was no way that an 07 policy could have included an 08 provision, but all United had to do, or all any insurance company had to do, was an endorsement. Now, understandably, the endorsements take some time to go through the Department of Insurance regulations, but if nothing else, they did, allegedly, they did send out the required notice, but the notice doesn't say we're adopting the fee schedule. Send out an endorsement or some other piece of paper that says the statute's changed and we are now adopting the fee schedule.
Ms. Reese, I want to go back to the impairment of obligation point. The constitutional provision says that there shall be no law impairing the obligation of contracts. How does the fee schedule impair the insured's rights in this particular case, if it's applied?
Because there may be circumstances in which, again, looking only at the fee schedule, and I think that the analysis has to be whether the statute as a whole impairs.
Let's concentrate just on the payout for the moment.
Because
I realize the statute has a lot in it, but let's just concentrate. Is there a legitimate argument that you can make that by incorporating that fee schedule as an alternative and giving the insurance company the option of paying the lesser amount, that there is an impairment? Where is the impairment? I'm trying to get at, is there a constitutional issue here or not?
If you're just looking at 5A2F and you set aside the fact that certain services cannot be provided if the fee schedule is incorporated and that sort of thing, there is a provision in here that says that the insured, and I would find it if I have just a moment, but it basically says that the medical provider cannot balance bill, which means that they can't collect the balance between the fee schedule. So that obviously in certain circumstances would benefit the insured. But there is also a provision in here that talks about copays. And there's a provision in here that says that if it's not compensable under the statute, then the insured has to pay the bill. So if the fee schedule is incorporated, then there are services that otherwise the insured would have been able to get, which would have been compensable.
Is that involved in this case? Any of those hypotheticals?
No, we're only talking right here about an MRI. But
You'd have been better off if this was an acupuncture case, right?
Or a faith healer.
Yes.
Yeah, I would have been, but I would submit to the court that again, and as I explained last time, the certified question was certified for the sole purpose that there are thousands of policies out there that are affected by these issues.
And there are only those policies that were purchased or became effective prior to January 1st of 2008, which was 3 years ago, right?
There are many.
That's really all. That's what this issue. Whatever differences there may be in those contracts that became effective prior to January 2008, from the standpoint of whether we take this case or not, the discretionary standpoint. The question, this only affects claims made under policies that were in effect prior to January 1st of 2008, correct?
Actually, as to this case, policies that were in effect prior to, that were purchased prior even to October 1st. Okay. This particular policy was February of 2007. So we're talking about a policy that was purchased long before even the legislature started talking about legislative enactment.
Anything prior to January 1st, 2008.
Right. There is the issue of the gap policy, which is another issue.
If a claim came under a policy after January 1st of 2008, the issue we have would not be present.
That's specifically the Kingsway case. And in Kingsway, which was a post-108 policy, the 4th District has said that if you're going to adopt the fee schedule, you have to put it in your policy. So there really are...
That's in all due respect. That sounds ridiculous.
That's between the districts. I think that the opinion was well-founded based on Nichols, but that's just my opinion. And if the court has...
Kingsway is a post January 1st. It doesn't affect, it's not any of these issues.
It's not any of these issues as we sit here today, because in Kingsway they actually had the opportunity to amend their insurance policy, but they chose not to. And then, of course, the Androsky case dealt with...
Did they choose not to, or they just didn't get around to it?
I have to imagine that...
In this case, did they send out, they tried to, you said something about that they sent out a endorsement, but it wasn't...
627-7407 has a notice requirement. It's not an endorsement because the endorsement has to be approved by the Department of Insurance Regulation. So they said by November 15th, you have to send out a notice, and the notice has to say A, B, C, D, and E. According to Mr. Hunker, and I have no reason to doubt him, although it's not in the record, that notice was sent out, but that notice does not say we are adopting the fee schedule. It doesn't, and their contract, as the court pointed out, doesn't say we are providing PIP benefits as amended or as will be amended from time to time. This is a policy that says these are your PIP benefits, and by the way, their policy does not include a provision to pay reasonable medical expenses. Their policy says we're going to pay 80% of medically necessary benefits. And Mr. Hunker is going to tell you that the definition section has defines medically necessary as reasonable, but that provision goes to terms and phrases that are bold-faced in the policy. And if you look at the PIP portion of the statute, medically necessary is not bold-faced. So that argument is not completely accurate. There is no definition in this policy or any reference to United paying 80% of reasonable medical expenses. They obligated themselves to pay 80% of medical expenses. They wrote the policy. It's an adhesion contract. It needs to be strictly construed. And they're obligated to pay 80% of medical expenses without even any regard to reasonable. So this case is even, I think, more egregious than any of the other cases that the court might say where there might
As a matter of fact,
be
egregious is not an appropriate expression.
well,
That's in any of this. We're all talking about money. We're only talking about who's going to say what money and what is relevant. And you're only talking about your economic interest. They're talking about their economic interest. There's nothing egregious about taking rational positions.
In my point of view, it's egregious to make a Florida citizen who otherwise may not be able to afford it.
If you represented that Florida citizen, you might be in a condition to be self-righteous about it, but you don't.
Judge, I apologize if I'm coming across as self-righteous, but I have an insured in this case who assigned her.
You don't represent that insured, and that insured could not care less how this case comes out. Is that correct?
I disagree. Thank you very much.
Thank you, Mr. Hunter. We'll give you 2 minutes for rebuttal.
I respectfully disagree with Ms. Reed's suggestion that this only applies to policies which were incepted prior to 1108. In fact, if you look at the argument that she relies on in Kingsway, if this court doesn't follow Kingsway, then we should, according to Ms. Reed, we should lose, because any policy incepted after 1108 that doesn't specifically reference the fee schedule would also be implicated by the ruling.
Would you be making this same argument if the service that had been provided was an acupuncturist who's excluded under the new statute, those services?
Actually, that's not entirely true.
You mean it's not, those services are not excluded under the statute?
They're not compensable under Medicare Part B, but the statute tells you if it's not under Medicare Part B, you look to the workers' comp. And acupuncture, there are 2 CPT codes where acupuncture is compensable under workers' comp.
How about faith healing?
Faith healing, our policy says we'll pay for faith healing. So if faith healing were at issue, the policy would control, because the policy would be in conflict with the statute. But what we're dealing with today is a policy that has no conflict with the statute whatsoever.
Your policy says you'll pay for faith healing?
It does.
Even if the statute says you don't have to pay for faith healing?
Well, we would be bound by that, because as Ms. Reese points out, the policy can offer greater rights than the statute. In that case, I would have to concede that we would have to pay for the faith healing. However, in this case, I think we're dealing with chiropractic.
You mean because you give greater benefits than the statute allows? Well, then if she's correct that the contract does not define medical expenses consistent with the statute, but is actually expansive and more beneficial to the insured, then she wins.
Well, you have to interpret insurance policies in a reasonable manner. Under her argument, if the first aspirin, if the provider charges $1,000 for the first aspirin, as long as that aspirin was necessary, we would have to pay the $1,000.
Let me ask it a different way. If we read the contract and we agree that the contract does not define medically necessary the same way that the statute does, but actually provides greater protection to the insured, then they win, because your contract would be inconsistent with the statute and provides greater benefit to the insured. Is that true?
I agree with the principle that if our policy provides greater rights than the statute, then the policy would control. I disagree with their contention that that's true in this case. I think our policy tells you to look to the statute on how to compute reasonableness, and there's no conflict whatsoever.
But getting to the bottom line, as to putting aside the fact that they represent we're talking about the MRI company and not the insured, but putting that aside for a moment. The fact is that you pay less money under the new statute than you do under the former statute.
That's true. But that doesn't necessarily make it invalid. I mean, the insured pays less as well, and we have to interpret the statute and the policy.
But he's not paying a less premium, is he?
He's not paying a less premium, but
he's not paying a less premium for this case. For this policy.
In this case, if the fee schedule isn't applied, there's $20,000 worth of bills in this case. The insured will be stuck with $10,000 beyond the policy limits. I think it's quite clear.
That is true. But the insured has to pay the same premium to you, regardless of what the benefits are.
And the way...
Wait just a minute. Sure. The fact is that under the MRI, you pay more under the first case than you do under the second. So it's costing you less money, and therefore the insured is getting less money, putting aside again the assignee issue. How can you say that it's not a substantive change?
But the way that
It's money.
well, but
That's money. If we're talking about the very discrete issue, as I insisted, I insist to myself only, I insist to myself that we should, how can you say that this change is not a substantive change when under one you pay $15 and the other you pay $10?
because I would submit to the court that it's a mutually beneficial change. I think.
Well, how is it a mutually beneficial? If the insured, they still have to pay the same amount of premium to you, and you are giving the insured, again, putting it aside, less money in return for the same money. So I don't understand how it can realistically be said not to be a substantive change. We're only talking about money. You're only here because you want to save money. They're only here because they want to make money.
Right.
There's no evil involved in this.
I don't take it personally, Your Honor. I think that this.
Of course, money is the root of all.
The love of money.
Yeah.
Not money. The love of money.
Whatever you say.
If I might have just one last word.
You mean that money is not the root of all evil?
No, it's not.
It's not just whether it's a substantive change. It's whether the substantive change harms the insured. Whether the change is more harmful than it
So you're
hurts.
suggesting that we engage in a Pomponio analysis?
I am, absolutely.
All right.
And I think all those factors lean in our favor because it's a very highly regulated area of the law, and this is not a substantial impairment.
If we think that there is a distinction between the assignee and the assignor as to that very issue, we could decide the case on a very, very narrow point, could we not?
You could.
Thank you.